Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. In preparing for the special 13-part series for the Indie Zone podcast, where I am evaluating the 13 current motions to suppress that are scheduled to be entertained by the court beginning 9 o'clock a.m. January 23rd, I noted something that struck me as potentially being a possible fatal defect for the defense in several of the motions that are on the public docket for two reasons. First, these motions incorporate Frank's type argument instead of suppression of evidence type argument, and the two are completely different. We've done many episodes on what a defendant must show to qualify for a Franks versus Delaware hearing, where it is the warrant affidavit that is being attacked, alleging that there is either an intentional misstatement there or one which shows reckless disregard, which is a very high negligence standard. That is the 5-part test that a defendant must show to even qualify for a hearing. Secondly, several of these motions to suppress reference and incorporate argument from their original Franks versus Delaware motion that was filed on November 14th, 2024, and was struck by the court on November 22nd, 2024. And in looking at the docket, the defense never sought leave to amend any of their motions to suppress that incorporate and re-argue as if fully set forth therein this separate filing which no longer exists. Let's go back over the docket to drive home what my points are here. First, Judge Stephen Hippler rendered an order on October 9th, 2024. This is, I call it the pretrial and trial order. It set a schedule for pretrial motions and other matters leading up to the jury trial in this case, which will commence in the summer of 2025. Under the section for the motions to suppress evidence, the defense was given a date certain, a hard deadline to get those motions in. What the defense did is filed 13 separate motions to suppress. Some are under seal, such as the motion to suppress the genetic information, the IgG evidence. Others are on the docket. All of them were filed on the 14th of November, 2024. And I'm going to give you an example of one of them. It is the motion to suppress evidence from Mr. Kohberger's Amazon account. And if you go to page 2, at the top, there's argument that says Mr. Kohberger, instead of introducing argument within this motion to suppress, he is incorporating argument from his November 14th, 2024 Frank's motion. So he's not providing a full-blown, standalone argument with case law here because he's relying on what's stated in the Frank's motion with some additional argument. But this motion also incorporates Frank's level argument, and we see it here on page 10 Under paragraph 2, see that reckless indifference or intentional misconduct? That's what you raise when you're attacking the warrant affidavit under Franks, not a motion to suppress evidence. A motion to suppress evidence is a much lower standard. What the defendant is doing on a motion to suppress is saying that the evidence was gathered illegally, not attacking the warrant affidavit for this high-level misconduct. That's the argument in the Franks motion. Now, there's several other motions that do the same thing. They're incorporating Franks-type language and also referencing to a motion that doesn't exist anymore. That Franks original motion doesn't exist anymore. The motion was struck. And the problem here, potentially, it's all how Judge Hippler is going to rule here, is that with respect to these motions to suppress, they incorporate argument from a filing that doesn't exist anymore. So perhaps, again, just throwing out my opinion under the First Amendment to the U.S. Constitution for educational purposes, as a citizen and a podcaster, perhaps the thing to do then, knowing that the motions to suppress incorporated argument from a document that's been struck from the record, the thing to do might have been leave of court to now incorporate the amended motion for a Franks hearing, which the defense did meet that deadline and filed it 4 days later on November 26, 2024. The problem here is that the motion itself is citing to a non-existent document. The defense doesn't have a motion for a Franks hearing anymore. It is an amended motion for a Franks hearing, and perhaps the argument's different, perhaps the exhibits are different. And again, they also, some of them incorporate in language, not for a motion to suppress, but intermingles language from the Franks motion. What are your thoughts and comments on this matter? I've provided a link to the documents. You can go in and look at them for yourself. Look at the record. It's pretty clear cut in terms of when the motions to suppress were filed and when the amended Franks motion was filed. The cart's before the horse here. Motions to suppress filed November 14th, 2024. Amended motion for Franks hearing filed November 26th, 2020. Might this be a problem for Judge Hippler? Might he say, hey, you've incorporated Franks language and you've also incorporated argument into your motion from a non-existent filing. You should have perhaps sought leave to amend. Again, my opinion. I'd love to hear yours. This is Kathy. Thank you for joining us here today.